So I think Gemma's having difficult. All right, thank you for all those answers. So I suppose the next question is, can anyone hear me, please? It's Sarah. Lovely, thank you. Oh, that's it's like a straw poll. we've got every variety there. How British. We'll blame the weather for everything. It would help actually if I spoke. So test, test, test. I'm assuming from what people are saying, actually, that people can hear me. If that's not right, yeah. Do you just want me to press on, Gemma? Yeah. Okay. Well, good afternoon, everyone, and welcome to this month's CECA Bevan Brittan webinar. Hope you're all well. Hope you've survived the storm. So today we're doing a slightly different topic from usual. So we're looking at a comparison of NEC and JCT. So I'm assuming both forms of contract are relevant to you because you've signed up. But even if you only use one form, I think there are two issues to raise. The first is that I think this will still be useful to you because it shows the differences. So the gaps in either form of contract. The other thing that I think is important is that whereas, I mean, we've got on this slide, the dates both contracts started life. And whereas 30 years ago, goodness, when NEC was introduced, the two contracts, NEC and JCT, were poles apart. Gradually, what we've seen in those 30 years is them getting nearer and nearer to each other. And that's not one meeting the other one. It's sort of an incremental amendments between for both of them, so that little bits of each have kind of been adapted to the other. So they are getting more similar as we go on. As I have done in the last few webinars, there are a few slides, particularly at the start, where there's a lot of information, but it was more to give you something to kind of take away so that you have lists in some cases, rather than for me to go through and explain everything in detail. So this is just a really brief summary of the history of NEC. So, I mean, NEC is still considered to be a new contract, and it was introduced in 1993, which is frightening for those of us who were around and working at that point. I suspect some on the webinar might not have even been born. Let's not go there. So yeah, NEC is almost 30 years old, but not as old as JCT, which goes back as far as 1931. So these are the slides that I was referring to. I'm not going to go through these in details, but this is basically the NEC suite of contracts. Now, in the 30 years, different versions have been brought out. So we're now on NEC 4. You're probably still working under NEC 3. I'd be really surprised if anyone has anything other than potentially long-standing disputes in relation to NEC 1 or 2. So this is the list. Now, when it was first brought out, the list was far, far shorter than this. And what seems to happen is that a couple of new contracts are issued whenever a new version is issued. So with NEC4, those two at the bottom, the design, build and operate contract and the alliance contract were introduced. But you can see that we've got everything here. Top two, we've got the construction contract and a short form. Next to, we've got the same for subcontracts. We've got a term service and a short version. Interestingly, under NEC, we have a professional services contract, so a consultant's appointment. We do not have that under JCT. So, that's an added bonus. And what I like about it is that it pretty much follows your other NEC contracts. It's not massively dissimilar. Whereas with JCT, you would usually have some form of bespoke professional services contract or possibly REBA, etc. Contract used. So completely different to the JCT. We've got supply contracts, including the short contract for when materials are being supplied. So it's not relevant for work being carried out on site, framework contract, dispute resolution, and of course the two that we've just mentioned. So hard to think of what else is we need or anything that's missing. But for JCT, and again, I've listed them out. We've got 1 slide, 2 slide, 3 slides worth of contract. Now, to an extent, this first slide are the contracts and subcontracts, but they're the different pricing options. So we'll have a look at how NEC deals with that, but that really accounts for the that first slide. We've then got the sort of ancillaries. So we've got short forms, subcontracts. We've got pre-construction services agreement. Now, obviously, what we've got in NEC4 is an additional X clause to deal with a similar situation. We've got management contracts. And then we've got things like framework, adjudication, and actually, repair and maintenance contract and a consultancy contract. Although I've never seen that consultancy agreement used in practice. So they're the kind of basic documents. So for NEC, what other documents are part of that contract package? Well, we have guidance notes, and if you come to these webinars, it's a rare webinar when I don't refer in some way to the guidance notes for NEC. They are very good. They're very helpful. In some instances, they just explain what the fairly simple wording in the contract says, but in some instances, it refers you backward or forwards to other clauses where it's not immediately apparent what the consequence is. JCT equivalent ? Well, yes, there is, but in my opinion, it's not as helpful as NEC. When we're back in the real world and hopefully soon doing proper seminars, you'll probably notice if you come to my seminars, I always bring along the guidance notes, because if someone has a question, I always refer to that as well as to the contract. NEC also has flow charts. I don't find them particularly helpful, but I suspect if you use them as a matter of practice, they probably would. And also the NEC run a Q&A. So, for example, I've got it on my Twitter feed. The Q&As come in and you can access it directly as well. So whilst it's not legally binding, it's often helpful. It gives specific queries that have been referred by parties and also gives the NEC official answer, so it wouldn't be binding in court, but some of them are very helpful in that they explain the ethos. So what does the NEC contract? So we're looking predominantly at the form of contract, the construction contract, the subcontract that you guys would be using, but very similar for most of the contracts, so the professional services framework, etc. So we have this very standard structure, which is helpful, but you need to bear it in mind. We have the core clauses, which are, I suppose, deemed to be the basic clauses you will need in every construction contract. So carrying out the works is clause 2. Clause 3 is programming, compensation events, changes, extra time. Clause 6, etc., etc. Termination, clause 8. We then have dispute resolution as an optional clause. So this is very much a key factor of NEC, which again we've seen creeping in to JCT as well. So now in JCT we have a number of schedules at the end, in particular one that relates to providing quotes for variations that are optional. We also have the secondary optional clauses X and the Y clauses. So the Y are to do with payment and the Housing Grants Act that we know about. The options X are to do with the kind of things that you would probably deal with in your contract particulars in JCT. So things like liquidated damages, delay damages, will they apply? What are the and what are the dates, what's the amount, that kind of thing, parent company guarantee, all these variables that you might want in a contract, you might not. And then we have the Z clauses, which are the amendments. And in JCT, what we see here usually is a schedule of amendments. And again, where we started off at kind of polar opposites, probably, as little time ago as 5 years ago, we've always for a long time now had a raft of JCT amendments. So that schedule of amendments, typically can be 15 to 30 pages, more in some cases. But up until about 5 years ago, the Z clauses in NEC tended to be things like anti-bribery clauses, confidentiality, but nothing major changing or amending the substance of the core clauses to NEC or the dispute resolution or any of the other clauses. That's all changed now. We're now seeing, again, 15 to 30 pages of what I call tinkerings. So, changing time limits in the existing clauses, removing provisions where typically the employer, the paying party, doesn't like them and wants them removing. So, some big changes there recently. We also have the schedule of cost components in NEC. What's that for? Well, it's to price any work that effectively hasn't already been priced. So I'm talking about work such as a fixed price or a bill of quantities has already been priced. So what hasn't been priced is compensation events, variations, time or cost of extensions of time, but also in remeasurable contracts, the costing for that. And then the contract data part 1 and 2, this is sort of the other part of what we have in JCT, which is the contract particulars. So it works very much with those secondary options X and Y and the W1, so these optional clauses in filling in the kind of key detail, key project information. In JCT, what do we have? Well, usually we have the agreement, so the deed of agreement, reference to whichever form of JCT contract applies, in this case D&B, the design and build, and various schedules which I've already referred to, which tend to be optional. The ancillary NEC documents, so it's not just the contracts, the sort of legal speak element of the document. There's also, as we have with every construction contract, a substantial amount of technical information so that we know what is to be built, what's included in the price, if it's a fixed price contract. So with NEC, we have the works information, or scope as it's now called with NEC 4. JCT, obviously we have the employers' requirements, contractors' proposals for the design and build. For NEC, we have the site information. For JCT, we have nothing. Now, there's a reason for that, and that's because under JCT, the site information is simply the responsibility of the contractor or the subcontractor under a subcontract. So it's in some ways a simple situation. Contractor is just expected to build and take account of whatever conditions it meets in terms of the site. NEC slightly different, but still quite limited in the potential for a contractor to make a claim. We'll see more of about that later. Other documents, collateral warranties, typically, for example, you might have a parent company guarantee, performance bond, ditto JCT. They still tend for both contracts to be bespoke drafting, albeit that particularly with collateral warranties, the bespoke drafting it tends to be very, very standard format. We have the activity schedule, stroke bill of quantities for options A and B. So they're priced options on NEC. So they're the fixed price contracts. And for JCT, we have the contract SUN analysis. Sorry, that's a typo and should be SUM. And lots of question marks for this last bullet point. We have the accepted programme. Now, question mark whether it's part of the contract under NEC, because it doesn't have to be. My view is for contractors and subcontractors, it's better if it is, because then it gets the accepted programme set in stone before start on site. If it's not in the contract, then contractor or subcontractor has the task of submitting a programme after the contract has been signed and relying on the project manager to accept it. If it's not accepted, then potentially you've got problems. And I've seen projects where the works have actually been completed without a programme having been accepted. And we'll see why that's problematic later. JCT, sometimes you do see the programme appended to the contract, but usually not. And again, we'll see this later, but there is no real requirement for programming in JCT. I'm not sure in this day and age that that's particularly a bonus or helpful to parties because of the reason that we need programs. So if you're a contractor or a subcontractor, basically you need that program so that you can then say, the work has changed, there's been a variation, there's been a compensation event, you, client, have delayed me, and this is my delay. Now, without that, without that program, it's quite difficult to do that. So, referred to this already. I'm sure you're all fully aware of this. So, if you remember, we had 3 slides of JCT contracts, partly because it covers the cost variables, whereas for NEC we have options depending on which pricing mechanism is going to be used. So it's A to F, A being fixed price lump sum contract, E actually, cost reimbursable, and then everything in between. So C and D is basically the kind of pain gain target contract, kind of risk sharing contract. So I put on the final column there just the professional services contracts that we have for NEC. So for obvious reasons, there's no bill of quantities or target contract with bill of quantities. So there's no option B or E or the management contract for obvious reasons. And here's a chart just setting out the pricing mechanisms under JCT. So, pretty similar, just a kind of variation on a theme, really. So next, I want to look at some of the unique features of NEC and sort of how JCT is moving towards what we've got in NEC. So this is sort of the next third of today's webinar, and then we're going to finish off with the final third, which is a sort of comparison of the two different types of contracts in various key areas. So NEC unique features. Well, first of all, we've got mutual trust and cooperation, clause 10.1. It's the very first clause in the contract. It's rare we don't talk about that in these webinars, albeit the caveat is that it's never going to, or it's rare that it's going to save anyone if there's a dispute, unless the other party has just behaved really, really badly. And by behaving badly, I don't mean that they've refused to pay a compensation event. I mean that they've misled you, for example, behaved dishonestly, that kind of thing. NEC, it's present tense short sentences, so the non-lawyers like it, the lawyers don't, because we're used to having contracts that say X party must do Y, and if they don't, this is what happens. And it's that latter bit that tends to be missing from NEC. Sometimes what you find is that it's covered elsewhere in NEC, which is one example of why I find the guidance notes helpful, because quite often the guidance notes point you in the right direction. And it's substantially a management contract. So, it is to be dealt with today, in the here and now. It's not to be put in the drawer, forgotten about, and then pulled out at the end to submit a big final account claim with lots of new variations, extensions of time, etc. It's quite innovative, NEC. So, for example, NEC 4 has some collaborative measures about proposals contractor, subcontractor can put forward for price saving for the project, for the cost of the build, and also for, and stroke, or for the kind of lifetime cost of the project. The design is fitness for purpose. Now, I've put that as innovative. I just think that's not great for contractors and subcontractors. The norm is fitness for purpose unless the reasonable skill and care option X15 is used. So please be careful, contractors and subcontractors. Always make sure that's included. And interestingly, in the professional services contract and this new design, build and operate, reasonable skill and care is the norm. So, if you're struggling to negotiate your X15 clause into the contract, they're two very good reasons to support the fact that it absolutely must be reasonable skill and care. No PII clauses. Again, professional services contract does require PII, professional indemnity insurance, and ditto the design, build and operate. So typically that is where or one of the amendments that is always made in the Z clauses. There's a nice limitation of liability clause at X18. So again, X clause, you know it's optional. You need to make sure contractor, subcontractor, that it's included, and also check what it says. I've said this before. I once saw whenever I review an NEC, you always kind of skim through, right, which clauses included. Reviewing for contractor, X15, check, yeah, great. X18, limitation of liability, yes, check, excellent. And then when I read it, it actually turned it round completely and limited the client's liability. So please do read it. This is one of the clauses that gets massively amended. So, you know, quite often it looks like a really nice limitation of liability, but actually once you've read it, there are so many carve-outs, particularly PII, all sorts of carve-outs that you'd be struggling to work out what exactly has been limited in terms of the contractor or the subcontractor's liability. So just be aware of that. And then finally, unique feature is additional QS and programming resources. It says may be required. I mean, I would go so far as to say absolutely will be required. We'll see this with the programming, but also, you know, the QS resource with, you know, this mechanism that we have of having to provide quotes for each compensation event. Far more onerous than JCT, albeit that JCT is going in a similar direction. So you are going to need, you know, a QS resource to deal with that, and a programmer. So continuing with the unique features for NEC, time and money, the programme is absolutely critical for the reasons that I've said. It's a very, because it's a management contract, so you're operating it throughout. You've got to have a programme that is up to date and reflects real time. Now this, you know, it's in some ways, you know, if you're the contractor, you know, it is a nuisance because it means you've got to have a programmer preparing the programme, but it can be invaluable if you have a claim at the end of the project, because you've got that contemporaneous evidence as you go along as to what was happening on site, and it avoids what we have usually with JCT, where you have a claim at the end of the project, you have to get a delay expert involved to try and work out from minutes of meeting and all sorts of documents how the project progressed. It's time consuming, and as soon as you're talking about getting experts involved, it's going to be expensive. There's no final account mechanism in NEC, so quite different to JCT, because there is in JCT, albeit quite a lot of people don't seem to realise it. However, NEC 4 has been changed, so there is a final account mechanism. So that's one example of where NEC is moving towards JCT in some respects. We have compensation events in NEC. They cover what I call the trio of additional money for extra work, variations, as we might call them under JCT, additional time, an extension of time, as you call it under JCT, and additional money in relation to that time, or as we call it in JCT, loss and expense. So, you know, you need to remember that's all covered and needs to be covered in your quotes when you're quoting for a compensation event. Compensation events are at clause 60. There's a long list, whereas with JCT, we obviously have a fairly wide and kind of quite vague definition of variations to do with any work carried out that's outside the scope in the contract or the timescales, etc. Don't forget that we also have compensation events listed in clauses X, potentially the Z clauses, and also the YUK2 clause. So, for example, YUK2, under the Housing Grants Act, if you have to suspend your work for non-payment under the Act, then it's a compensation event that you get paid for your cost and your delay for having to do that. The CE process, the compensation event process, killer deadlines for potentially for both parties. Again, this is sort of in JCT, but we have a combination of not using specific time limits with JCT. So usually it's that it says forthwith or as soon reasonably as, etc. So whereas with NEC we have specific deadlines, which is why psychologically they always seem to be killer deadlines, and they have that killer wording in that we need to look for where it says contractor must do X, and if they don't do it within X weeks, then they don't get paid, something like that. And it's that key bit that's the killer. If they don't do it within X weeks, don't get paid, but still have to do the work. Early warning notices, new to NEC, unique to NEC, although I have seen them amended into JCT. And finally, just to mention the Northern Ireland Housing Executive case, my view is this is one of the most important cases in relation to NEC. It's interesting, it's a 2017 case. As you will guess, if you look at the title, it's a Northern Ireland case. So it's persuasive to our courts, but we don't have to follow it. I suspect we will, but basically where we have quotes for compensation events and extensions of time based on programs that have been prepared up to date throughout the project, what this case sort of does is rides a coach and a horse through that by saying if it actually gets to court, what the court is interested is in the actual cost. So not interested in quotes. What they're interested in is when the work was complete, what had it actually cost? And also with regard to delay, never mind what was kind of quoted as the prospective delay at the time, what the contractor thought the delay would be. What the court is interested in is what was the actual delay, which we can only work out when that bit of the work has been complete. So just be aware of that. That's no reason not to do your quotes or keep your programme up to date, because it's all helpful evidence, and particularly keeping your programme up to date. But what it also means is that unfortunately contractors, subcontractors, you still need to keep records to show for a compensation event who was working on it, when, how many hours, what were they doing, all that critical information to prove your cost and the time involved. Some of the tricky bits in the unique features. So first of all, dispute resolution. You've got to adjudicate before you can go to court arbitration. Now, probably for contractors and subcontractors, that's absolutely fine. That will suit them. Potentially for the employer, the client, they're typically going to be adjudicating for defects. They may prefer just to go straight to court or arbitration. there's nothing to stop the parties coming to an agreement, but which probably would suit the contractor as well. But bear in mind, you must adjudicate first. Also note, and there's nothing like that in JCT. Also note, you've got to submit a notice of dissatisfaction within 28 days of an adjudicator's award. It's a killer deadline. If you don't submit it within that time limit, then you're deemed to have accepted the adjudicator's award, and you cannot proceed further. You cannot go to court or arbitration to re-argue your case at all. Note the importance of the works information. And this is, the works information, the scope of any construction contract is really important because it sets out the work that you're going to do. It's more important, the detail is more important in NEC than it is in JCT because of the opportunity to claim for extras, stroke variations. I've already said with JCT, variations fairly loosely worded in JCT, whereas with NEC, it is quite specific wording. It talks about things like it's a compensation event if the client fails to do work that it is supposed to carry out as set out in the works information or programme. And if it doesn't do that, then it's a compensation event. So it is very specific. The work that the work that the employer has to do has to be set out in the contract documents for it to be a compensation event, and that applies to all sorts of variations compensation events. Note also the distinction between the site and the working areas. That's relevant to payment under the schedule of cost components. So for compensation events for options A and B, and for D and E, it's basically how the contractor stroke subcontractor will be paid. Also note the distinction between risks and the risk register. Don't see people getting caught out by this so much now, but they used to. The risk register is just listing risks. It's a sort of health and safety document. It is, I can't stress this too much, all it is listing potential risks. It is not saying which party takes the risk of those events happening. The contract deals with that, and typically, if in doubt, it's probably the contractor stroke subcontractor who bears that risk. So please do not look at the risk register and think, great, all these risks are down, which means that, they're not my responsibility, they're the client's. Also note the distinction between delay damages and key dates. What we have under NEC is a dual system of key dates, which is a date you have to meet to finish a specific piece of work. The ordinary penalty for not meeting that is that the client can bring in their own people to finish off and charge the contractor for that, as opposed to delay damages for finishing a section or the whole of the works, which is usually liquidated into a specific sum or can be general damages. So there's nothing like key dates in the JCT form of contract. Also note that the key dates penalty, shall we call it, or consequence, sometimes gets amended nowadays. So I've seen provisions where not only can client bring in third party to complete the work, but can also do various other things. So just be careful about that. Next bullet point, activity schedule and bill of quantities relevant for cost options A, B, C and D, not works information. It's merely for pricing. So if you're thinking, this is really important for contractors and subcontractors, if you're thinking, right, well, my activity schedule says that I do X work and I get paid £20,000 for it, that is not setting out your scope. It only means that once you've done that work, you get paid your £20,000. It doesn't mean that other work that's in the activity schedule or the bill of quantities doesn't have to be done by you because there's no pricing attached to it. It simply means it's all included in your price. And site information, as we've already said, possibly a CE. We'll see a bit more of that in a minute. NEC getting paid. First of all, you need to salami slice your activity schedule because you get paid for that when you've completed an activity. So if you salami slice it, you get paid regularly rather than having to complete a huge chunk of work, which might take months. No inability for options A and B because they're your lump sum contracts, your fixed price contracts. You cannot claim the cost of preparing compensation event quotes for those. Be careful about that because, you know, as we've already seen, you're going to need extra QS resource on the project. And I've seen relatively small projects balloon, you know, sometimes double in value because of compensation events. Particularly problematic where there are lots of small fiddly compensation events because it involves a lot of QS time but not substantial amounts of money in terms of claims. So just note that. General difficulties with the schedule of cost components and the shorter schedule. This is all to do with, so we know the schedule of cost components is to do with your fixed price contracts, claiming your compensation event money, so fairly limited, but still important because of course the compensation events can add up. For the remaining contracts, it's to do with what you will get paid. Very prescriptive. Generally it's fair, but you just need to make sure that you get it right and it works, it sort of meshes in with the contract data part 2. So you need to make sure that you understand that so that you don't miss anything. And bear in mind that anything that isn't included within the schedule of cost components is covered in your fee percentage. So that's your OHP, insurance premiums, recruitment costs, I think, you know, other things like that. So now on to the final third. So this is the sort of comparison between the two forms of contract. So some of this will be slightly repetitive with the unique features of NEC. So in terms of the contract documents, we've already referred to this, that the technical information, the scope is in the works information for NEC, or of course for NEC4, it is now called scope. JCT, employers requirements contractors proposals, as far as the design and build is concerned. As I've already said, for NEC, it is really important, this document, for compliance with compensation events. Next bullet point, contractor completing the contract data part 2, really important for payment provisions. So what we've just seen, your fee percentage, the point about the schedule of cost components, all that information relates to the contract data part 2. So it must be completed properly. Don't do what a client of mine did once, not a CECA member, I would add, where they'd signed the NEC form of contract and they'd completed their name and address in the contract data part 2 and the rest was blank. JCT, the equivalent is the contract particulars, but it's also, so the contract particulars deals with certain things. So for example, amount of liquidated damages payable, but for things like valuing compensation events, so for JCT that would be a variation, or valuing loss and expense, it's very much done on the basis of what were the contract rates. If there were no analogous contract rates, then what's fair and reasonable? So whilst you can have a debate about, the contract rates, what's fair and reasonable, there's very little risk in JCT that you've got a lacuna, a big gap, where you haven't got the ability to price for something. There is more so with NEC. So, contractor might want to include rates in the contract data part 2. That's fairly common, rather than use its actual cost in the schedule of costs components. And as we've seen with JCT, you're on the contract rates stroke fair and reasonable rates. Next bullet point, Z clauses. I put a question mark there because I would just say, as I've already said, JCT has a schedule of amendments, NEC has Z clauses. My experience is 15 to 30 pages of amendments in each nowadays. And finally, the NEC subcontract really nicely slots in and steps down the obligations. So, my advice, if you're subcontracting and you're on an NEC contract, would be to use the NEC form of subcontract. I just think it makes administering the contract so much easy. All of the timescales slot in, so subcontractor gets slightly shorter timescales than the contractor to mean that the contractor can comply with its timescales, even if it needs information from the subcontractor. To an extent, the same is true of JCT also. Money, so the financial side of things, we already know NEC has this unique feature of early warning notices, and what we should know is that the penalty, the result of non-compliance, of failing to issue an early warning notice, is that your compensation events will be valued as if you had given one, so potentially that's a deduction for your compensation event. No such kind of feature in JCT. We've already talked about this, these set time limits, notifying a compensation event under NEC, killer time limit, 8 weeks under the main contract, 7 under the subcontract, and the fact it covers the 3. It includes your variation, the extra money, extra time, and your loss and expense. Sort of ditto for JCT, because amendments to JCT typically mean that contractors and subcontractors end up in a worse position than they do with NEC. So what they end up with is a timescale that's even less than that 7 or 8 weeks, so typically 2, 3, 4 weeks. And that's not to say, when NEC is amended, typically you can expect that timescale to be amended as well. NEC has a requirement to submit quotes, but as I've already said, because of the case law, that Northern Ireland case, you really need to keep your actual cost records and timesheets, etc. In JCT, we have separate clauses for each of variations, EOT, and loss and expense, and there are different procedures to follow for each of them. So you just need to make sure that you follow those. So for NEC, you need to make sure that you include all 3 in your quote. For JCT, you need to make sure that you are notifying each of them separately, but that you always operate with it, thinking about all 3. Next bullet point, default notices issued by contractor through the compensation event process. This is the mechanism that helps contractors to make sure the client complies with the mechanism for approving quotes and keeping the project moving. So if you remember, we've talked about this in other seminars. For each step that the project manager has to take through the compensation event process, if it doesn't do it within the required timescale, the contractor can send a notice that's written, served in accordance with the contract, saying that the project manager hasn't complied and giving the project manager another 2 weeks to comply. If the project manager still doesn't do what it should have done, then there's a deeming provision. So if, for example, project manager hasn't accepted or rejected a quote, then it's deemed to have accepted it. So that is really, really valuable tool for contractors. So I would advocate using it. Don't please get muddled. You must send that notice. I still get asked by people, project manager hasn't complied with the initial time limit, so it's deemed accepted. No, it isn't. You've got to give them that second warning, I'm afraid. Nothing like that in JCT, but of course the time scales, the time limits are, not as harsh as they are under NEC. As we've seen, strict list of compensation events, whereas the variations in JCT are more widely drawn. And same subcontract point that we've made before. Few miscellaneous points. Actually, this should probably be called programming. So the requirements are very prescriptive for programming under NEC. First program must be submitted, or there can be a 25% deduction on your account. JCT generally has minimal provisions about programming, unless the schedule of amendments amends provisions in. Fairly strict programming requirements within NEC, and the point about a programmer being required to provide all these programs. I mean, I would say you will be on a project providing at least one program a month, plus a program for any compensation event where there's been delay, and potentially plus others. Just looking at the X clauses under NEC, so we already know X15, you've got to opt into reasonable skill and care. It's a must if you're designing. Contractors and subcontractors. In JCT, it's a standard clause. You don't need to worry about it being in there. It's automatically in, unless the schedule of amendments amends it to make it fitness for purpose, in which case you need to negotiate it out. The X18, limitation of liability under NEC, which we've talked about already. Contractors use it. It's a good clause. The provisions in JCT aren't so good. So there's a limitation for consequential indirect losses in the design and build, assuming it's opted into. So the amount of the cap will be set out in the contract particulars. Typically it's not used, but of course it's only for consequential indirect loss, and there's very little loss that is truly consequential or indirect. Loss of profit is a direct loss, and in some cases loss of opportunity might be a direct loss. So, it's not a great limitation of liability. You might want to kind of pull the NEC limitation in, subject to amendments. X4 is the requirement for a parent company guarantee. Again, if it's not submitted within time scales, it's a ground to terminate the contract. There is a requirement for parent company guarantee in JCT, but not with that termination. Now, as I say often, it's unlikely because, of course, PCG is going to be submitted very early doors in the project. So it's really unlikely the client's going to want to terminate unless something else possibly has happened and they use it as a tactical reason to terminate, where they want to get a new party in or whatever. And note to clients, employers, don't forget to include the X clauses that you require, so particularly completion date and liquidated damages. Payment, pretty much the same because, of course, it's all pretty much dictated by the Housing Grants Act. It's not something we can avoid in construction. So if, for example, a critical point, employer, project manager, contract administrator under either contract doesn't issue the relevant payment notice, pay less notice, then potentially, assuming contractor or subcontractor has submitted an application for payment, payment's going to be due under a smash and grab adjudication. Oh yeah, no provisional sums under NEC, but there are under JCT. Ground conditions we've already seen. I've already referred to the fact for JCT that ground conditions are just not mentioned, and that is because it's wholly the contractor's risk. The contractor says in JCT it will build a building, a facility, whatever, and that means that it will build it at the site that it's to be built. So, don't be fooled into thinking that for some reason that, because it's not in the contract, it's not contractor's responsibility. It is the reverse. It's a limited compensation event in NEC based on the site information that's provided and what a reasonable contractor would have allowed for, taking that into account and a variety of other things. So it's fairly unusual that there would be a compensation event for ground conditions under NEC unless there is a specific issue where the parties have specifically agreed that a specific condition would be a compensation event, and the provisions provide for that. The NEC provision is often amended, sometimes removed to make the JCT provision prevail, so that it's removed so that contractor is effectively responsible for those ground conditions. So another example of where it's quite often amended to make it more like JCT. The finality of the final account, again, already mentioned this. JCT has these provisions in, I think it says all JCT contracts. I don't think that's actually correct. I think possibly the minor works contract doesn't contain it, but most of them do. So just be careful about that because it provides various, they're quite complicated provisions, but effectively provides various timescales where each party has the opportunity to put in the final account, and if the other doesn't object within a certain period, killer deadline alert, then that party is deemed to have accepted it, can't adjudicate, can't go to court, you're deemed to have agreed it. It's like a binding agreement on the parties. NEC doesn't have that except for NEC 4, where we do have it. So just be careful if you are starting to work on an NEC 4 contract. Just think ahead that when you get to completion, you need to be thinking about these provisions to make sure you don't get caught short by them. In terms of claims, the compensation events, I think we've kind of done this to death. So we'll skip that one and finish with just a summary. So as we started off by saying, NEC is a prescriptive contract. JCT less so, more wriggle room. Sometimes that wriggle causes problems because each party will wriggle, and you end up in an adjudication. So which one works best, who can say? It probably depends on how well you are able to fulfill the requirements of the NEC as you work through the project. As I said initially, they are getting more and more similar as time goes by. NEC, though, is still very much a contract that you need to be reading as you go along. You need to know particularly what the scope of work is, whose responsibility it is to do A, B, and C. In particular, if you're a contractor or a subcontractor, you need to be really clear in your works information about any work or materials that you are not supplying and who is supplying them and when they're supplying them. And I suppose not, so it says ditto there with JCT. I mean, obviously that is best, it's something that's best to be clear on, but not critical. So happy to deal with any questions. I think my email address was on those slides. So as always, if you'd rather drop me an email, happy to deal with questions that way. Can't see any. Well, I hope that means that it's all crystal clear. We still can't hear Gemma.
I don't think anyone can hear me. But
okay, well, I'll finish off for Gemma unless she wants to type something. Thanks everyone for attending. Gemma will send the slides around. If you've got any questions, send me an email direct. That's no problem. And thank you very much for attending. Hope it's been useful.
Thank you, everyone. Apparently some people can hear me now, which is a miracle. So I've sent out some details on there just to say that we'll be sending a copy of the slides out to everyone, and there'll be a link to the recording as well. Everyone should get a link through to a CPD certificate. So for those who can hear me, please do that. I'll send an email around to everyone else anyway. Thank you very much for attending today. Thank you, Sarah. All right. Thank you, everyone. Bye.